Now I will introduce you Dr. Diogo Casqueiro, who is a leading practitioner at the corporate department of the London law firm Allen & Overy, and will speak on the licensing principle and peer-to-peer lending.
Thank you very much. Thank you, first of all, to Centro de Investigação de Direito Privado, Professors Dário Moura Vicente, Diogo Pereira Duarte, e Doutora Catarina Granadeiro. It's a pleasure to be here. Thank you also to the EBI. And thank you to Professor Eugenia, who has taken a big chunk out of my presentation as well. No, because obviously there are investment-based crowdfunding aspects that are common to both types of investment-based crowdfunding. So with that in mind, I will probably focus on some of the loan aspects of crowdfunding that are specific, and my intention for this presentation was, in light of the stated objectives of financial regulation in the EU, assess how those have been implemented by the regulation in the specific cases of loans. Now, one of I think the first point that I wanted to make was, when in typical and traditional lending activities, what usually happens is you don't deal with these small amounts. You almost always deal with more sophisticated investors and lenders, and you also deal with, therefore, contractual terms that have a degree of complexity that are inadequate for these types of products. However, because of the standardized format of contracts that need to be presented to investors on the platforms, there is a case of investors not fully realizing what they can do and what is that they are signing up to. For example, there is, if I am lending to a new business via one of these platforms, is that business allowed to dispose of its assets, to create security, to search additional credit on secured funds? Now, the disclosure obligations under the regulation don't specifically address this issue. And so you can theoretically find yourselves in a position where investors are signing up to contractual terms, and they may even see the stated contractual terms, but either not understand them or not have a full picture of what it is that the business can do. So this was the first point that I wanted to flag in relation to lending via platforms. The second point that I wanted to flag is, which is more, I wouldn't say specific, but more, I think, presents more seriously in the context of lending, of crowd lending, is the issue of cash drag. So cash drag is a situation where there is an imbalance between supply and demand, meaning that the number of investors that are willing to contribute cash into the platform are more, for some reason or another, than the number of projects that are available on the platform for investing in. And then the issue arises, so I have basically contributed money into the platform, and that money is sitting there idly and not doing anything. And there can be discretion as to how the platform allocates cash between investors into the different projects. The regulation tried to address this to a certain extent. The first, mainly through the concept of individual portfolio loan management, which is basically asset management for loans. In essence, saying, the regulation did try to say that, basically on a principal approach, say that there is an overarching duty to act in the best interest of clients and search the best possible outcome. But it hasn't really gone into the depth of saying, what happens? Do I need a policy in this respect? What is the level of disclosure? So and also, if there isn't an individual mandate and auto-investing criteria that have to be followed, what is exactly the situation there, and how is the duty to act in the best interests of the investors going to materialize in that situation? So cash drag is also an issue in this respect. Another point on which the regulation, I think, merits some commentary is on the topic where loans are concerned, is on the topic of client assets and segregation. By their very nature, loans don't usually qualify as securities and will therefore consist in a transfer of cash. Now, cash being the most fungible asset that there is an evident problem of ensuring cash segregation, of achieving cash segregation. The regulation tries to address this by disclosing what arrangements have been put in place, notably for the safeguarding of assets. But unlike what happens in certain jurisdictions, cash will ultimately always be unable to be segregated from the assets of the entity that is the depositary of the cash. So there is an extra layer of risk here that would merit additional considerations. The last point that, from a specifically lending perspective, that I wanted to address, and that is directly linked to the licensing principle, is the cross-border provision of these services. So the licensing principle is the foundation for, meaning the requirement to be previously authorized to be able to market these services, is the foundation for then the authorization to then provide these services in other jurisdictions. Now, there is a conceptual issue that previous panels have alluded to here, which is the market has become so diverse and the business models are so diverse now that it is quite tricky to exactly pin down what the services and the activities are. Also, there is a recent example of how of what a source of legal uncertainty the regulation can be in terms of cross-border of these services, which is the case of MiFID II. Under MiFID II, when MiFID II and the regulation MiFIR were adopted, there was a European regime for the provision of cross-border investment services, but that was dependent on the European Commission specifying a list of jurisdictions for the purposes of this provision and arrangements with third countries that were in place as a condition to the provision of those services. What happened then was that the European Commission didn't publish that list, and that basically led to each member state having to regulate the provision of those services at a national level. When that happened, there were substantial discrepancies in the way that each member state regulated the provision of investment services, and as to how each member state decided whether a service was being provided in that member state. The regulation on the regulation here for crowdfunding providers doesn't give any indication of what the criteria are that need to be followed to consider whether an activity or a service is provided in a certain jurisdiction. There is an extra layer of complexity on this, given that a distinction has to be made between activities and services. And the reason for this, and this is particularly acute in the case of crowdfunding platforms, because crowdfunding platforms are basically, in the first instance at least, they're there. And so it's a platform to which I can get access under certain terms. And so it then becomes a question, does the simple fact that I exist and an investor from a different jurisdiction comes to me means that I am providing a service or an activity in another jurisdiction? So on the one hand, you have the activities side of the platform existing and people reaching out to the platform. On the other side, you have the actual services of the platform. And it will depend on the business model. If I am merely putting together different parties and providing some ancillary services, I am not really engaging in the business of lending. However, there have been cases reported where the platform itself was keeping a book, meaning that it would borrow and then lend against its own balance sheet. The FCA in the UK brought the market's attention to this, notably because there were potential licensing issues there as a taking deposits activity, but also because in that case there was the issue of determining whether the lending was taking place by the platform itself. All of these issues, in terms of the provision of cross-border services by these platforms, need and merit further guidance. The traditional approach on this has been goes back to a communication by the European Commission saying that we should have regard to the characteristic performance of the service and where that is located. But the EBA has recently drawn the attention of investors in the market that in light of how technology is advancing, that criteria may no longer be a suitable criteria for determining whether the service is being provided in a certain territory. The last point I wanted to raise during this intervention was basically relating to the fact that, and again, this will depend on the business model it will depend on the business model of the platform, but there are circumstances where, in essence, the platform may be acting as agent for what we usually call the facility agent for finance parties, meaning that it may be performing administrative functions for the benefit of the lenders, and that will almost undoubtedly be the case if the product isn't structured as direct loans between each investor and the project owner. In that case, what you usually need to do as well is you need a number of provisions in your documentation saying how those rights are going to be exercised. What are the majorities for the agent to take decisions in relation to the credit? And all of these are provisions that have been thought of for a much more sophisticated market, notably the big TLB markets in London, private equity acquisition finance, and that are not suitable for the type of credit products that are being discussed here. With that in mind, there is cause to ask whether investors are really in a position to be able to assess and understand those provisions, and also be able to effectively exercise the rights, in addition to the question as to whether the platform then does require additional licenses to be able to act as agent. So these were, looking at the regulation, and I do agree with Professor Eugenia that there are elements of MiFID that have underpinned the type of regulation that we are faced with. But but there are also elements which don't seem to cater for the specificities of lending products. And so there is an additional case to be made for the specificities of this product and whether this regulation or additional regulation should be introduced. Not because we need to further constrict the activity, but because the specific risks of the lending products are not necessarily adequately reflected in this regulation. Thank you very much.